Can a person who is previously declared incapacitated and given a guardian and is also a relative of a party be a process server in a matrimonial action? To find out, you have to read W.G.G versus J.D.S. But it's 15 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where normally I cover New York Court of Appeals cases and I try to do it in 5 minutes or less. This is the episode on the recent case of W.G.G versus J.D.S, published by the Nassau County Supreme Court, Judge Dane, on March 6th of 2024. The citation for this case is 2024 New York Slip Opinion 24072. And the issue in this case is whether an incapacitated person who's a relative of a party can serve process, can be a process server on a matrimonial action. This is relevant because a lot of our cases involve guardianships or elder people who have been declared incapacitated or have dementia, something like that. So I want to talk to you a little bit about the background, law that's helpful to understand this case, the context. CPLR 5015 talks about a vacatur of a default judgment and basically says that a default judgment, which is a judgment found for a party and against the other party, in the absence of participation by the other party. That's what a default judgment is. The party that has been defaulted against, the loser of the default judgment, can vacate the default judgment on motion by any interested party made within 1 year of the entry of the judgment, as long as they have a reasonable excuse for the default and a meritorious defense to the action or motion. And reasonable excuse is a discretionary fact. It's a discretionary conclusion that a judge can make after analyzing all the factors that are relevant, which includes the extent of the delay, prejudice to the opposing party, the willfulness, the public policy considerations. And after an assessment of all those things, the judge can say, I find a reasonable excuse here. I will vacate the default. The other thing you have to know is that CPLR 2013 talks about service of process. And it says that except where otherwise prescribed by law or order of the court, papers may be served in an action by any person, not a party, who has attained the age of 18 years or over. And Professor Siegel, in his treatise on this, says a hominid, any human being, 18 or over, not a party, can be a process server. Okay, so what are the facts here? The facts are that this is a matrimonial action. It's an action to dissolve a contract of marriage. The parties were married in 2016, and in this particular case, the plaintiff is the husband and the defendant is the wife. And the husband, the plaintiff here, has a son from a previous relationship who's over 18. And that son, we'll call him S. They call him S in this decision. S has a previous history of being allegedly mentally challenged and was the subject of a guardianship in New Hampshire, was declared incapacitated in New Hampshire. So the plaintiff, the husband, when he decided to file an action for divorce, he had his son, S, serve the papers, be the process server. The defendant, the wife, failed to appear for the preliminary conference in July, for the compliance conference in September, for the inquest in October, and ultimately the judge conducted an inquest and issued a judgment of divorce. At that point, within a month, the defendant wife came forward and moved to vacate the default, said, hey, I was never served. I never received a single paper about this. I only know about it because we lived together and I saw on the kitchen table or the coffee table a bill for a divorce lawyer. So I came and I realized what was going on and I want to vacate it because I was never actually served. She claims the affidavits of service that the son filled out were falsified, and the fact that he's mentally challenged and declared incapacitated by the state of New Hampshire and had a guardian appointed who's actually the plaintiff means that he cannot be a process server. He cannot serve the process in this case. She said he's not authorized to effect service because of his incapacity and his relationship with the plaintiff. The plaintiff opposes this, says he's not mentally challenged, said that he was his guardian in New Hampshire but not in New York, and he concedes that his son had a guardian, but there's no longer a need for a guardianship, is what the plaintiff says. Goes to the judge here, Judge Dane, and the judge conducts a multi-factor analysis with those factors we talked about to see, and ultimately concludes here, the holding in this case is, he says, the court concludes that a person who is a relative of a party who has also been found by a court to be incapacitated, cannot serve process in a matrimonial action. Why? It goes through the facts. It goes through a couple of different arguments here. It says service upon an incompetent person has to be done on an incompetent person and their guardian. And the court can excuse it on the incompetent person. Therefore, they are not capable of engaging in this kind of a process. Secondly, the judge says, because the son was declared incapacitated in New Hampshire and he lost all these basic rights like to marry, to enter contracts, to initiate and settle lawsuits, he can't. The court says the court is dubious that a person who cannot do all these things can serve process and swear to the efficacy of service for a lawsuit. Thirdly, the judge says the plaintiff was the son's guardian in New Hampshire. So anything that the guardian can control the son. So if the son actually performed this action, it was really the plaintiff performing it. So that's a problem. And finally, the judge says one of the things that the son couldn't do because of the guardianship was initiate, defend, or settle lawsuits. And if the son can't initiate, defend, or settle lawsuits, the son can't then be a process server. He can't understand the duty of service of process. So the court then finds that because the son was not authorized as a relative who's incapacitated to serve process, the process was a nullity. There was no process. And ultimately, considering that factor along with the other factors, the judge finds the default should be vacated and vacates it. And that's the case of W.G.G. versus J.D.S. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.